welcome to Objection to the Form. We've got a special guest this week, Ashley Michael. Welcome, Ashley.
Hello, good evening.
I really appreciate you being here. Ashley's not feeling great today, and you're a trooper for coming out and braving the elements, and so I'm looking forward to talking a little bit of collaborative divorce with you.
Well, thank you. You've been so great to reschedule for me. I've been a little under the weather, but
Well, I'm excited to have you here, and since the first couple shows, we've been trying to get a family law attorney to come on, and I know what we're going to be talking about is a little bit different from your traditional family law case, but it's definitely one of the areas that I get asked about the most, and that it affects most people's lives, and that can have some of the better stories and some of the more the more entertaining and things people like to hear about. But we're going to talk about a more positive end of that today. But first, before we get going into it, could you kind of explain generally what collaborative divorce means, and kind of what that, because it's a fairly new concept or a fairly new approach to handling divorce.
New approach as far as not new to our laws in North Carolina, but newer to the public. And that's certainly one of my personal missions, along with some of my friends and colleagues in our state. And hopefully we'll get some time to talk about that. But yes, let's say what collaborative is, and collaborative divorce specifically. It's a voluntary legal process where spouses or parents, because maybe they're not married, but they share children, choose attorneys trained in interest-based settlement negotiations to solve difficult, certainly emotionally charged conflicts, because we're talking about your money and your children and your things, to separate and to divorce without going to court. And we do that all outside of litigation, no courtroom, no judge. And the parties do that with counsel, so they each have to have an attorney and a specifically trained attorney. And so hopefully we'll also be talking about that today. And they do that together, and they build a contract. And the four of us do that together. So attorney, party, or client. And they are controlling the outcome of their contract. And they put whatever legal needs they determine they want in that document, such as custody, support, equitable distribution, spousal support, into the document. And in doing so, they're controlling the outcome. They're communicating, they're managing costs, they're managing their privacy. And what they're showing is a dignified end to the marriage or the separation. They're showing an ability to co-parent. They're showing their friends, their community, their coworkers that they don't have to, what we as attorneys in my world call, burn the proverbial house down.
Yeah, and I think the word that you used that I picked up on the most of this was voluntary. So it's not necessarily, from my understanding of collaborative divorce, it's not a situation where you're going to go before a judge and have your outcome determined. That it's maybe more analogous to a mediation or something of those lines, where you can where the goal is to reach an agreement rather than to present your side, to present your evidence, and hope that the judge sees it your way.
Right, absolutely voluntary. And so in court, so I think maybe where we should start is to maybe explain the different processes in family law. So I'm more of a non-traditional family law attorney. I think a lot of my colleagues in town, you go and you litigate, or you build a separation agreement. So you're either going to the courthouse and you're walking out with having that court order handed to you, and your clients are dealing with the outcome whether they like it or not. And that's the adversarial approach. That is the, building your case, building your evidence, and that's difficult. You don't have control of the outcome. It's costly. There's no privacy.
And do you find that it's a divorce context when you're dealing with the folks? So it's two people that more likely than not were having difficulty getting along. For now some of them are more bitter, or some of them are there's more anger, or sometimes people just grow apart, and it can be kind of a friendly one, so to speak. But it seems like a common thread seems to be one spouse is trying to get over on the other one, or maybe they're both trying to get over on each other, and it's kind of a thing of, it's like, well, what I remember from my family law days is you might, as the attorney, reach what you think's a fair settlement or resolution, and then the one side's almost like, well, if the other side would agree to that, something must be wrong, or I must be missing something. Because
No.
the ultimate goal is to get over on their ex spouse.
All of the things you are saying are absolutely true. It's a game. It is a contest, and the model of court. It's not that I'm saying anything negative about the judges or the system. It's a system. It's there. It puts the parties on the same playing field. It gives you logistics and opportunity and a time, and it will come to an end. But what it does force, as you were saying, is it forces the parties to almost bring out the worst in each other. It does force the parties to bring information and evidence to the court, especially in terms of custody and parenting, to try to one-up the other, to try to bring out bad information or negative information, to hope that they're going to tip the scales in their favor. It becomes unfortunately, a character battle, a pissing match. And that's what you see on TV. Those are the courtroom ramas, the TV shows, the movies. But one that perhaps is the only one as an attorney, and you can appreciate this over the years, that comes close to anything that rings true is The Marriage Story. And so I don't know, it's been on Netflix for about 2 years now. It's a beautiful story of the antithesis of collaborative.
That depressed me. I didn't make it through the end of it. I remember, like, I tried to watch it. I think it was nominated for an Oscar, and I remember looking through it, and it was just, it reminded me of the Breakup, the Vince Vaughn and Jennifer Aniston movie, where it was just like, I just got tired of listening to them argue and couldn't, it just, maybe if I'd have made it through long enough, I would have gotten to see maybe there was a happy ending to it, or they resolved things amicably.
No.
They didn't. Okay. So
they go through, well, at least the father does, different lawyers.
And he's the one from Star Wars, right?
Yep. Tons of money. The child literally in one scene is being physically pulled by his arms by each parent. They one-up each other. And one of the attorneys, it's the one for the mother, becomes a therapist for the mother. And it is sad. It is depressing. And it is a really true look at what happens in litigation. And the other part that you brought up, as far as if it's not going to court, because the parties that do go to court really feel that they can't talk to one another, they can't see eye to eye, and they need the judge to give them the outcome. The other alternative you gave is, can the parents or the parties talk to one another, and can their attorneys work it out? And that's the separation agreement. That's getting along at least enough that somebody bends, somebody gives in, and they work out a document, and they're signing that document, and that is their divorce agreement, their contract that resolves issues, so they don't have a judge tell them how they will spend the next 10 years with their child, or sell their house, or end up with what's left in their retirement.
Yeah. And, with what you're talking about with the kids being lumped into this, and, I guess the term that people use for it is, rather than referring to it as a custody action or a custody case, you hear people talk about, well, I'm in the middle of a custody battle. Like you don't, in other fields, like if I'm doing a personal injury case, it's not like, well, I'm in a personal injury battle against the insurance company, or I'm in a, I'm in a real estate battle against my neighbor about our fence, but it's like, custody, when you're talking about kids, is the only really type of legal action where it's referred to as a battle.
Yeah, true.
Well, so you were mentioning the separation agreement approach. Is that the end goal of a collaborative divorce? Is it trying to reach a separation agreement?
It is. But the difference in just working with an attorney who talks to another attorney who's going back to their client, and you're working on that contract, that separation agreement. So again, don't have the court, don't have a judge. The parties are trying to build that contract. The difference in collaborative versus an attorney-led negotiation is the parties actually are communicating with each other. And so what you have is you have attorneys that are trained in a different form of communication and negotiation model, and it's called an interest-based negotiation model. It's a complete paradigm shift from what you and I went to law school for. And in the last, I would say, 10 to 13 years, which is earlier than when you and I went to school. When you and I went to school, we had to take a class in alternative dispute resolution, right? We had to take a mediation or an arbitration class.
Yep.
And nowadays, when you're graduating, collaborative law is one of your choices. And instead of positional bargaining, which is mediation, or it is litigation, now collaborative is your interest-based negotiation and the shift in your mind of how you talk to one another.
So what you're describing to me sounds like that book, Getting to Yes.
It absolutely
So
is.
is that part of the collaborative process?
It's the part that does feel so similar to mediation, but our mediation has shifted also in the 13 years since it's been a part of our family court bar, and it's unfortunately just become a document collection opportunity. Seeing when you can find out what the other side is going to present in court and what their case in chief is like.
I thought that lawyers weren't allowed in the custody mediations.
Well, you can do private custody mediation,
Oh,
but
okay.
I'm more so
Yeah.
thinking about our family financial mediation, which
Oh,
we have
yep.
to do before
Yep.
we go to court. But as far as getting to yes, and the book you're talking about, it absolutely does talk about different tips and tricks for finding out what matters in the heart of the person you're representing. And that's, in a nutshell, your interest-based negotiation. It is your wishes, your values, and not your positions. It's the why behind the want. It's not just the I want, it's the I need.
Yeah. And is there an underlying basis in law, like where, you would be child support? Is it, so for example, so child support, the guidelines kind of spit out a number as long as you're within, kind of normal income range, where you just tell them your income, the other child's parents' income, any child support or any other child obligations you have to support other children, your health care expenses for the children, and then work-related child care costs. You just kind of plug that into a formula, and it spits out your child support obligation. So does it work the same in collaborative law, where you're using kind of regulations or laws to reach a support obligation? Or are you looking more at what do I need to support the children type thing?
So, in your example, I think what would be totally different is we're going to go more in depth in that child support conversation. We're not just going to look at a worksheet. So, the attorneys and the clients, we're going to be in the same room together. So it's not like mediation where we're going to be in two separate rooms and someone's going to shuttle that information back and forth. We're going to have an organic conversation that is going to have much more depth to it. And we're not just going to look at one resource, which the law says, for example, in court, that we have to follow. And we're going to hear from the custodial parent, the parent that would be receiving child support, if we look at that worksheet and we populate it. And it says that parent's going to receive $700 a month. And then that parent says, oh my gosh, that's really scary. That's not going to work for me. But we're not just going to hear that parent say, that won't work for me. We need to hear the why. And then we need to hear dialogue back and forth from the other parent that's going to be paying and what that budget looks like. So we're going to go levels down from just on its face what that number is on paper, and we don't have to follow what the law says. That absolutely should be a perspective, a guide, a grounding point for everyone, because worst case scenario, if the conversation fails, the separation agreement, as you said, is a voluntary process. Nobody has to sign on that dotted line. It goes to court. Otherwise, we need to know what a judge would do. But to have the conversation about, it could be A, which is the child support guideline worksheet. Here's B, about what the child needs for a budget, what the parents can and can't do for the finances, and what that looks like in both houses. And what we end up with that conversation is the synergy of brainstorming, the understanding of what it's like in two households, and what little Johnny really needs, and what that $700 is going to be spent on.
Well, that seems like a refreshing approach that certainly can help relieve some of the angst that people are going through in that process. So we're going to take our first break of the evening, and when we come back, I'd like for you to kind of take everybody behind the scenes of what a collaborative divorce case or negotiation or however you want to frame it looks like, and kind of I want to know more about how it works because I think
Absolutely.
it's certainly an interesting subject. So we'll be back with that in just a moment.
Thank you.
All right, we're back at it. TK, I like the selection today. Getting hyped up to talk about divorce. Excited about it. So when we left, we were getting ready to talk about what does a collaborative divorce look like. So I want to take it from the very top. So spouse, I was starting to say husband and wife, but we're 2021. Who knows what it could be? It could be two spouses. We don't know what it is, but we know two married people are calling it quits, and they want to go their separate ways. They don't want to. They've seen the divorce story, and they don't want to go through that. So they're saying, let's try collaborative. So from the start, like if that's, I mean, I know that you do collaborative just from knowing you over the years and whatnot, but let's say for just your person that's listening that might not know anything but's concerned about the potential of what litigation could look like, how would you go about saying or locating a collaborative law attorney?
Sure. So not all family law attorneys are trained in collaborative. So for one thing, you've got to find an attorney that knows what they're doing. So we've got 50 so family law attorneys pretty proficient in our county, couple thousand in our state. But first, you've got to reach out and find one that is trained in collaborative.
And that's what I was going to ask. So is there like a listserv or like a list where I can look up who's got the collaborative law certification within my jurisdiction?
Yes. So the bar, you can check with your bar just for the areas of law, so your local state bar. And then, Google it, check with your websites and call around. So I would say as far as the buzzword and collaborative law, collaborative divorce, it is becoming more popular. But collaborative divorce, as far as statutory, it has been an option now for 18 years in North Carolina. Other states are more progressive than us. California would be one of them. But so, your state bar, practice groups, and then, just attorneys.
I've got a bigger, kind of a bigger picture question for you. How is collaborative law? Is collaborative law viewed differently by the states and by just kind of than a negotiation strategy? Because when I'm looking at, you're saying like being recognized for 18 years. I mean, what you've described to me so far seems like a kind of a way to resolve all the issues that are incident to a divorce. But is it really a separate set of laws and things that apply, or is it just
how our collaborative divorce statutes fit in or within our family law statutes only assist to toll or pause if you have an existing family law case in court. So to answer your question, I would say that judges in North Carolina, and I won't say names, but specifically a few of our local family court judges love collaborative because what it does is it gives the control back to the parents or the spouses, and they are solving their problems. It's helping the state with the judicial backlog. We do not have efficiency. No state does. And a contract is controlling the outcome. I mean, poor judges, they have so much pressure in that, they are solving the riddles of a family, their livelihood, their next 10 to 18 years with their child, like a horse with blinders for a couple hours that day in court. And it's not that they give cookie cutter outcomes. They certainly don't, but they're doing their best. And the people that can give those more appropriate outcomes are the ones that have all that information.
Yeah. I mean, I think that's exactly right. Cause it's like to you, or to the litigant or to the participant in the case that you've been participating in it for however long. And, your hearing may take half a day, a couple days, but you've more likely than not been living with it for a year to 2 years, several years before you reach to your hearing, and you're dealing with a judge who's just kind of you're just kind of um, they've heard these things time and time and time again, and it's really hard um, to not just be another number or to um, make them understand what you've experienced through that whole time.
And the judges only have so much time. I mean, the clients, they want days in court. That they don't understand that attorneys have to battle the caseload, the calendar. Your client might want 2 days to talk about their custody matter, and a judge says, and it's not the judge's fault, but it's the system that we have to work with. The judge says, I'll give you half a day, I'll give you a day, and the client says, my case is going to take a week.
Yeah.
So, the client's frustrated walking into court, they're frustrated walking out of court. So with collaborative, as opposed to what you were saying earlier with the attorney-led separation agreement, you're having a conversation with the person that their decisions matter to. You're not having a conversation with a brick wall.
So in your typical divorce situation, it seems like more times than not, maybe one side wants the divorce more than the other, or maybe one side sprung the issue up on the other, but kind of with our scenario of how does this work? So you approach your spouse and say, hey, this isn't working for me. It's time to get a divorce. I was thinking rather than we fight it out in court, let's do collaborative law. I've taken the liberty of going to the state bar's website, and I've identified, maybe how many collaborative law attorneys are certified in New Hanover County that you're aware of?
There are about 8 of us. There's not many. It's a niche practice.
For sure. And then so you tell your spouse, all right, so I've identified 8 attorneys that we could work with for this type of divorce. Now, do the attorneys participate in selecting their spouse's attorney, or do you just say, look, I've gone to Ashley and she's going to be my attorney, but you might want to get one of these other 7, or is it a joint decision who represents each party?
So 2 things here. One, more so in collaborative than other legal paths, the parties usually, statistically, are not physically separated yet. So they're communicative enough in cases where they haven't, one hasn't left the household. So they are dialoguing. Another point is that, yes, one has sought out collaborative law. They figured out this path of collaborative divorce. And so one has found the attorney, and then the attorney, in this case, me, I'm giving a list, and I'm saying, here's a group I work with. We have efficiency protocols. We've worked cases together. We know each other. So here's a stepping off point. Here's other people you can check in with. But the pandemic has done really neat things for collaborative attorneys in the past year, and attorneys, in many other areas of law, because we can Zoom. You can have an attorney in Raleigh that has more years of practice in collaborative than I have. I've got 12 in, but I work with an attorney last week in Raleigh that is considered an expert in collaborative, that started the first practice group in the state. So we're not just limited to the 8 that I mentioned that I've worked with and trained with initially over the years. So, but typically it is that first spouse that has found collaborative divorce, that has gotten that consultation and is savvy in the area of law.
So when the 2 parties, or the two parties of the marriage, have both secured their own attorney that's certified in collaborative law, what's the initial step? Is there a joint meeting with everyone, or is there a exchange of information?
And one of the things I want to mention before we jump into that is, I would say one of the cons that people need to be aware of, or at least I've heard in feedback over the years from parties, is collaborative is not going to work for someone or for parties if they don't understand that it takes both of them to hire an attorney. So they both have to be willing to have an attorney, because collaborative is not going to work if you don't have each party vested with legal counsel. Because to have that session, to have collaborative sessions, it requires attorney, client, client. and you're each having modeling and education and assistance to have those synergistic conversations in the room. I can't lead someone else's client or be an attorney to two people in that room and help have those brainstorming interest-based conversations,
Yeah.
right?
Well, that's an interesting point because it's the closest thing to that exists outside of the collaborative realm would be maybe your mediations
Mm-hmm.
where you're giving your client's view of the case, but you're still not necessarily interacting directly with the person. You're kind of
Right.
you're projecting and you're communicating your position, so to speak, or the way you think a judge will see the case, but you're not. It's not interaction. And the only thing I guess you may have interaction in a deposition. I guess that could happen, but it's not. It's about specific questioning and trying to elicit facts. Well, okay, so then you've got.
So we have our first session, and it's called a pledge session.
Mhm.
And some of those statutes you were bringing up that I said that fit right into our family law statutes is we sign a contract at this first session, attorney, attorney, client, client, and that protects the parties from anybody going to court, from anybody engaging in a lawsuit. It actually tolls our family law statutes for statutory purposes.
Yep.
And also, if there had been some prior litigation, then we can use that contract and send it to our family court judges or that open court file, wherever it is, and say, we're going to pause things for whatever length of time we need to. And that preserves their rights in a child support action or in a spousal support action, a marital fault issue. And in that session, what we're doing is we are educating and modeling the clients about how we need to communicate. And a lot of them in this interest-based negotiation model are kindergarten rules. So I had a pledge session yesterday, and I always giggle when I say, a lot of these things you remember from your child's kindergarten or pre-K class. It's, speaking respectfully. It's
Yeah.
I statements. It is, being empathetic. It is treating the other with dignity. I mean, if you need to take a break, take a break. So it's talking about communication. It is teaching them this paradigm of the values, interests, needs. And so that's a lot of what we do in this first session. We're creating what we call the container for these honest, open, transparent sessions that we're going to continue to have.
Okay, so you're not. It doesn't sound like you're getting that deep into the merits at this point.
We do, in the last half of the session, start to lay out what areas of law we're going to be dealing with for our contract. So we start setting up the bigger pieces and parts of our contract, and we start talking about our action steps. Clients don't like to hear the word homework, but that's what it is.
All right.
We talk about our document gathering. So one of the things in collaborative is that everybody's going to take a role here, and we're going to assign what those roles are so they each feel like they're creating or being a part of the process. And we set deadlines to those action steps, that homework, that document gathering. We've got to be educated so we can make good decision making, right?
Yep.
So we're going to do that. And the parties are also going to agree on what they're going to collect, what they need to have to, make decisions about the retirement. Can we sell the house? Do we need an appraisal? Does it matter if we're looking at the true date of our retirement plan, or is it just data separation retirement plan? So they're making some of these decisions. Then we're not signing anything.
Yeah.
It doesn't vest, and we can't change our minds later, but we're setting a timeline for the next meeting. We're setting an agenda for the next meeting. So it's not a wasted appointment.
Yep. Well, that's so we're going to take our second break of the evening, and then when we come back, I want to hear about the document gathering process, and then kind of what's done with that information once you've done your homework, so to speak.
Absolutely.
All right, we continue our journey into collaborative divorce, and where we left off is you've gone to your pledge meeting, you've committed to the process. You and your spouse have selected their certified collaborative attorneys. You've met, you've agreed to act in good faith and to gather certain documents that are going to be required for the process. And I imagine the documents are things, you outline a lot of it, like, what are our debts? What's our income? What do we have any, what type of, besides what you'd imagine from putting together a financial picture, are there any other type of documents that you're required to gather?
Well, it becomes whatever is going to be synonymous with that family or that couple's separation agreement. So we're having a broader picture then of what areas of law we're going to tackle, what's going to go in that separation agreement. And we've already, or at least I have a workbook, that I've created that I am talking out with clients before. So the attorneys, we are briefing clients, and we're still having our attorney-client privilege and confidentiality conversations.
So you meet separately with your own client, and it's not like everything is together.
Right.
And you mentioned kind of this process where you're not advising the other attorney's client. So are you just there and participating in a discussion? Can you engage the other party to the marriage directly?
We can educate them. We're not advising them. So we're having these global, organic, synergistic conversations together about those interests. So how do we want to solve college? Do we want to go above and beyond our typical child support? And do we want to prepare for college savings for little Johnny?
Mm-hmm.
And so we can advise another attorney's client on that in the room, and that is not violating any of our ethics because of those statutes that we talked about earlier. And also some of those other statutes that are the collaborative divorce that, walk hand in hand with our family law statutes. We talk about confidentiality and admissibility for court later. And actually, one of the things with collaborative is that if the process does fail, and so low percentage here because there's so much buy-in to the process. We've worked so hard together. We've shared so much information, all those hours clocked in with that, efficiency, that if it does fail, the attorneys, we can't be the litigation attorneys because we've learned so much about the other attorney's client at the table.
Yeah, I didn't think about that, but that makes a ton of sense.
Yep. But the information that we share is, think about discovery. That is still able to, go into the court system and just like if you would have subpoenaed documents.
So then so everybody brings their information, and at the second meeting, do you have experts looped into the process yet by the second meeting?
So at the end of that pledge session, or at really any point in the process, we're going to talk to the attorneys are going to talk to the parties about, do we need any third-party neutrals? Do we need, does little Johnny have a therapist? Do the parties actually have their own individual therapist? Do they have a marriage counselor? Are there, or is there a need for a financial specialist? So there's actually other third parties that can be collaboratively trained that we call specialists that get the collaborative training in our communication, in our interest-based negotiation, that we want to bring into, that are resources for the family, that they agree to hire for a singular purpose that works with both of them, that talks to both of them. Nobody hides information. We pick one of these. We pick a party, say an accountant. They're not having dueling resources, dueling providers, paying for two appraisers. And we're bringing that person maybe into the session to share the information to help us with problem solving. It's not in every case.
Now, let's say you're just trying to determine the value of the marital home. Do you have to have an appraiser that's trained in collaborative law, or is that's just kind of
easy peasy? You've got your $350 to $500. Call up your real estate agent you like to work with, get a recommendation.
$350 to $500. That was last year.
So
there's
low rate before the boom.
Oh yeah, the appraisers are in demand. I'm seeing
$750.
Yep, so that's right. $750 to $800. Yeah, so you get your $750 to, and most of them are going to tell you it'll be a couple months before they get it because they're it's crazy what's going on right now. But okay, so you've got.
But you don't always need somebody extra at the table. But we might be saying to the parties, there's some things that we need, and that's going to bump us back 2 weeks or a month before we meet. And so those are going on those action item steps. We're agreeing about it. We're setting the timeline to it. It's not a unilateral process. We're having these conversations together. We're agreeing on them together. Who do we need to talk to? What do we need to get? What's the timeline? When's the next meeting? And we're setting those agendas. So there's usually 3 conversations. One of them's about little Johnny. So it's the co-parenting conversation.
When you mentioned the specialist, like as far as therapy and things of that nature, uh, is the purpose of that towards crafting the final agreement, or is it just for overall mental health and kind of just well-being?
It can be both. I would hope that it's the end goal is to getting the client, if they need one, and say the therapeutic or mental health component. If you've got a client that can't come to the table, can't come in the room, can't get their mind wrapped around, say, the separation, they weren't the one that left, but they know it's going to happen one way or another. If it doesn't happen here at the proverbial table, it's going to happen in court. And maybe they need a coach, a therapist. There's a bunch of different terms we can use, an advisor, and maybe they need that professional to help them get in that mind space to negotiate. So maybe it's for the now to help them get to negotiation.
So are there certain types of specialists or experts that need collaborative training, or is it typically you just got to see what's available?
There are going to be some areas in North Carolina that are rural and smaller, and they don't have therapists, financial specialists, mental health specialists that have collaborative training. And so hopefully attorneys have relationships or can have conversations and vet those professionals and explain what collaborative is. And I'll tell you, in the mental health world, we're not going to have problems finding somebody because they embrace these mental health and therapists. They embrace collaborative. They know how good it is to get out of a bad situation, right?
Mm-hmm.
Financial specialist, a lot of your CDFAs, certified financial divorce analysts.
I had no clue that was such a thing.
Yep. So they already have heard about collaborative, and they might already be trained. They just haven't found a group of attorneys that they work with, maybe in some of the smaller areas, not the bigger communities in the state. But financial specialists, the main thing is they just need to rework their fee agreement and understand that they've got to work with both. They can't keep information from one spouse. They need to think about how they're sharing and meeting. And we also don't always need to bring these professionals into the session. I have a term I use all the time. I don't want to make things bigger than they need to be. I don't need to create, more billing, more money, more time. So anytime that we bring in and make the case interdisciplinary or multidisciplinary for the needs of the parties, because every case is going to be different, we're going to discern, the attorneys, the clients, the team. We're going to discern what those needs are. Do they need to be in the room, out of the room? The parties, can they do it together? Can they not do it together? So it's all going to be different.
Yep. And so I guess is typically, is there a third stage meeting, or is it formulaic to the extent where it's like we've got our pledge session and then we're going to have our second session where we bring back our homework, and then we've got a third and a fourth, or is it just after the first couple, it's just as many meetings that it takes to get it done?
I mean, I could say easy answer, as many meetings as it takes to get it done. But to speak out of the other side of my mouth, there's 3 overreaching stages. And the 3 conversations are little Johnny and the co-parenting session. Then there's a cash flow conversation. And then there is the contract as a whole. So typically, you need to know what's coming in, what's going out, and we need to work on a budget, because usually 90% of parties that are going to separate are going to have 2 households. We don't have, families that come from money and just automatically, somebody's grandparents or parents are going to sweep in and buy a house for them and
Yeah.
put them at the beach house at Wrightsville.
How would you compare and contrast the end results, besides the money spent on litigation and that sort of thing, but just for your average supporting spouse? Would you say that your supporting spouse tends to end up paying more or less through the collaborative process? And I'm just talking about the end result. I'm not talking about the money spent on litigation and, because sometimes that's your risk as a supporting spouse is you end up fighting for years and then you pay for everybody's fees. And that's a big risk. But just, are you looking at probably paying more than you would if you go through the legal process in collaborative?
No. Got to think about how you answer that. I think you asked two different ways. In collaborative, because you're talking about the interests, the needs, the values, and not just the positions, because what supporting spouse is going to willingly just say, I'm going to pay you what you're asking for, or what supporting spouse walks out of court and is okay with what the judge, banged the proverbial gavel and said, you're going to pay $2,000 for the next 8 years. I mean, they're not happy. So in collaborative, I think that they're usually going to pay less. And I think that they're going to pay less than what happens to them in court because the conversations are more intertwined with what is paid in other areas and why.
Yeah.
So it's more about looking at the big picture in pieces and parts and not just the big picture. Because in court, we've got, our 3-step process for spousal support. We've got the definition, supporting dependent. We've got the 2 households and the 2 budgets. And then we've got who's operating in the red and black. And then do we have money left over and do we have a need? And then that's what goes to pay. And then we have this random, unknown, unweighted 16 factors and one's a catch-all. And then it's that character match in court.
Yeah.
And in collaborative, it's back to we're still going to do all those same steps and apply the spousal support test. But in collaborative, supporting spouse knows, okay, I'm going to have to pay. But the dependent spouse is going to say, well, okay, I know I need some money. And the supporting spouse knows I'm going to be asked to pay some money. But they're going to have a conversation about what's this money going towards?
Yeah.
And what does that also mean if they have a child? What does that mean for little Johnny? Well, is mom going to use that money to go to school? And then do we really need to have some random half amount the years of marriage? So for 4 years, I'm going to be stereotypical and say the dad's going to pay. Well, can we switch that and have an automatic modification as soon as mom gets a job or as soon as X, Y, and Z happen? So there's going to be more of those deeper conversations about modification or springing points because they can do that in a contract. And those things aren't going to happen in those attorney-led separation agreement conversations because we're talking to a wall. We're not talking with each other.
Well, and another thing about that situation is, with the kind of the formulas involved in child support, they're very, I tried to outline the limited amount of input, but you can have a situation where, well, let me ask this. Can you pay below your guideline child support amount in a collaborative agreement?
Sure.
And so as long as it's both parties contract.
Parties agree. They cannot pay child support. They can say we're doing fine enough on our own with our respective budgets in our respective household. Let's start saving for a car. Let's start saving for college. They can do whatever they want.
And it's not modifiable. Because I've always heard that child support, it's like you can have whatever you want by contract, but ultimately you can always go into court on child support where, you can on alimony maybe or equitable distribution, but in child support, it's been my understanding that you can always take that to court.
It depends on what you do with your contract, and it depends on your separation agreement. It depends on what the parties and the attorneys advise and educate and decide how they write their contract. Do they put that into a consent order at the end of the collaborative sessions?
So if you don't want it change, if you don't want it to be subject to change, I would imagine you're going to want to keep it out of a consent order.
You would want to.
Oh, you do?
You'd want to do a non-statutory consent order.
Oh, all right.
And you'd want to tell the story. You'd want to write in there why you did it, so the judge knows more about the meeting of the minds too.
Well, that's learn something new. I appreciate you letting me know that. So we're going to take a very quick break, and then I want to kind of wrap things up when we get back, talking about gray divorces, and which is kind of a recent trend
Sure.
and difficult to deal with. To kind of wrap things up today, I know there was some statistics that I wanted to get into with you about just the status of divorce in general in the United States, and kind of how maybe this collaborative approach can help things out.
Sure. Actually, as I was preparing to come on the radio, because I can speak in court and, and run a mediation and talk all day long. I mean, attorneys were natural orators, but I was definitely nervous about being on the radio. Definitely easier than TV because nobody's looking at me. But I decided that I needed to look up a couple things because I figured statistics would be fun for radio. And I happened upon something that's new to me. Statistics just came out 2020 for 2019. The Institute of Family Studies, and what they do, this group, is they look at CDC data and National Vital Statistics, which are your state vital records, where your marriage, birth, and divorce records are filed. And it'll be interesting to see what falls out from this, because there was a disclaimer from IFS, Institute of Family Studies, that says these 2019 numbers are out, but the understanding behind it is not out yet. And it said that in 2019, last 50 years, divorces have started to hit a record low. And I thought, what is that? Because for the last 50 years, so 2018 and behind that, everybody hears these statistics that half of marriages end in divorce, right? That's awful. That's a really high rate. And
coin flip.
Yeah, wow. And CDFAs give us statistics that say the reasons are 43% are basic incompatibility, 28% are infidelity, and 22% are money issues. And then other statistics say that 41% are first marriages, 60% are second marriages, and 73% are third marriages. Gosh, I mean, people just keep trying, wow, props to them. And so that leads me to mention gray divorces. And so that's a term for these marriages that are later in life. And there's not exactly a number. It's not like you're 50 or 60 or 70 years old, but it's, I would say you're more 60 and older. And gray divorces, these are clients that, as they are later in life, they're older individuals. I mean, they have higher wealth. And these are clients that I think are perfect for collaborative divorce because they're educated. They are in having a higher net wealth. They want to protect that, right? They also want to protect their privacy. They should not. One of the things about collaborative is if you are not going to the courthouse, everybody doesn't have access to your financial records, whether or not you have committed infidelity with, your neighbor across the street. There's we've got somebody in the booth laughing. But I mean, look, that's 28% of infidelity, 22% of the money issues. But in these couples that are older, they're more of the savvy, more of the intelligent consumers.
So what about those statistics do kind of surprise me a little bit. I've heard, and it's just anecdotally, that divorces are on the rise right now because of COVID, with people that are sick of hanging out in the house with each other all the time.
It's going to be one or the other.
Yeah.
So it's going to be either, unfortunately, they can't afford divorce, or they are so, beyond their spouse and the claustrophobicness that they are leaving, and they are leaving fast. And the thing about collaborative and cost, A typical, even just own a house, have a retirement, 2 cars, have a child, going to court $10,000 to $50,000, and it's going to take a year. Collaborative is $3,000 to $10,000, and you're going to get done in a couple months.
It seems like a no-brainer to me. So our time's about up this evening, but Ashley, can you tell everybody about your firm and where you practice and how they can reach you if
Sure.
they're interested in working with you in a collaborative divorce?
Absolutely. So I'm with Craig and Fox. I'm a board certified specialist in family law. There's only 4 of us in town, and only 216 board certified specialists in family law in the state of North Carolina. So I'm very proud to be one of that group. We have 4 attorneys at our practice. We're a boutique law firm. We have 2 board certified elder law and estate law attorneys at our office. We are still working very effectively in the pandemic. We are downtown at 701 Market, and I've had 14 years of practice. I also litigate. I take that hat off for collaborative divorce, and I'm an adoption attorney. I'm a mediator. I'm a parenting coordinator. I love what I do.
Yeah.
And thank you for having me.
Well, thank you very much. And we're out of here. So yeah, please go see Ashley. I think she's someone I would highly recommend for any collaborative, or if you want to go the traditional route and go for a battle. She's who you want on your side.